Is 8:26, and we're continuing the work of Lieutenant Natural Resources and Energy on page 687. We have draft 1.1 time and date saying 4/26/24, 8:38 AM. Prepared request of committee by council. We are on the 7th instance of amendment, which appears on page 6. Okay,
So,
take us through this one.
I'll ask you, Office of Legislative Counsel, so on page 6, the 7th instance of amendment is amending section 52, which is on the zoning limitations on certain facilities. And so the new language is in yellow. What you sent in your bill is the first part, hotels and motels converted to permanently affordable housing development. So the language that's not shown is that municipalities are limited in what aspects of these developments they kind of regulate. It's a limited subset. So you're adding language here that says, however, permanently affordable housing unit converted from a hotel or motel room shall be equipped with a kitchen and meet any other local minimum housing standards. This was proposed by Senator Watson yesterday, but you didn't see the language. True.
Okay. Right, should be equipped with a kitchen and meet any other local municipal minimum housing standards. Okay, so.
You're gonna call it a house? Sure. Yes.
Ms. Dimitri, you, the lot has fallen to you to speak on behalf of all municipalities in the state of Washington. Powerful position. From your experiences, do municipalities generally always have a list of minimum housing standards?
No, but those that do, I think would truly appreciate this language. And in fact, it may actually encourage some of them to adopt a local health, but that's just that.
Okay, Senator Watson?
I did consider adding, and any other local municipal, minimum housing standards if applicable. Knowing that not all of them do, however, even if they do not, if you're gonna convert a hotel room to a housing unit, it should have a kitchen, so, regardless. I didn't wanna just rely on the minimum housing standards.
Yeah, I think it's a positive change that means I will appreciate.
Okay, that's one piece of it. Sarah McDonald, you had the interesting question during the break of what's the difference between a kitchen and a kitchenette?
I Googled kitchen. And it was mind-boggling what they talk about kitchens and kitchenettes.
Sure.
And
So what is it you have to have?
Ms. Haskell? Mr. Gill?
We were discussing the different, what we thought the difference was, sorry.
Oh.
Nothing from an active
Yeah.
perspective.
No kitchenette.
Just thinking of French.
The cigarette and the cigar example, where to start.
Ms. Dimitri?
I'm wondering, I think your council highlighted the connection with accessory dwelling units earlier, if perhaps that same language about, the food preparation and that more specific language could be used in lieu here. Because I don't think, unless it is your intent, I don't think you want to suggest that kitchen needs to be a separate room.
Right,
That it
that's
could perhaps be a studio configuration, and so maybe that accessory dwelling unit language could be.
That phrase including sleeping, food preparation, and sanitation.
So it's a distinction that need not be made. But what is one?
A requirement that's important by doing it in such a way that it is flexible.
Watson?
I would be happy to, change the kitchen specifically to match the ADU language, which conveniently is both on the page. So.
Is this a gender proclivity?
Sorry,
It's just a gender for living.
I don't think so.
Actually, we.
My ex-wife always wanted it.
Oh, yes.
I'm sorry, I went.
Oh,
No, it may not be that, but that's an interesting.
You raise the issue of gender, though. The feminine, suffix, to mean small. I've heard complaints about that.
no, I'm,
Kitchenette, feminine kitchen.
I'm going to
Okay,
continue my thoughts.
Thank you, please, help me out.
We have
Free association period now ends, it's back to the bill.
So perhaps instead I could say, however, each permanently affordable housing unit converted from hotel or motel room. Shall be equipped. With however, has, and I'm starting from line 2. A hotel, sorry, from a hotel or motel room, shall be equipped with facilities and provisions for independent living, including sleeping, food preparation, and sanitation. I don't know that we wanna
As
go,
defined by,
same as the ADUs. And then continue on with any other local minimum housing standards. Perhaps that's too much. Maybe we just wanna say, because the issue really is the food preparation. So, because there's gonna be a bed there, so maybe we don't need to say including sleeping. So perhaps instead, shall be equipped with facilities and provisions for food preparation and meet any other local, whatever, concession. It also looks like maybe.
the other alternative, Mr. Chair, would be to put out the rule.
Which
Would have wide bunch of hearings.
we know you love.
We do this. And then we get into arguments about, it's a farm product. What isn't, what you can or can't sell. But those discussions take place after we've created the ambiguity.
Ms. Sullivan,
Megan Sullivan, Vice President of Government Affairs for Mountain Farmers Authority, to walk in and apologize if you've already talked about this. There was an issue at some point in a community that was building units for memory care
Yes.
and the requirements for patients. Is that, I didn't see that.
no, this is different, but
Okay.
we talked about it the same way, like Fairhaven, I think, with that project.
Yes.
Um,
I can come in. So I was thinking about that as well and wondering about what is the likelihood that we would change a hotel or motel into a memory care unit? I mean, that is possible, but especially because hotels and motels. Right, affordable, well, because, I mean, it was just, like, if a motel room walks right out into the street.
More likely to be a hotel, I would say.
Right,
than-
yeah, so I feel like that's a distinction that. Maybe worth making in the future, like, do you know what I mean, like, I feel like the likelihood of that running up against each other right now is pretty low. For it would be for a hotel room specifically. I don't know that we can make that distinction right now, so, but I give you. Okay, that's how I was thinking.
So can you rewrite 7 to borrow language from 6 that relates to these kinds of provisions for sleeping, food preference and. Please,
Yes.
Also,
I don't know, if we need, I don't really, I don't know if we need a however.
Well,
How provided that, or anyway, however, thought, anyway, we don't
Well-
usually say. Go ahead.
It is in conflict with the list above.
Which is why the however is.
So, I mean, I think you could. You need to make some indication that this is disjunctive from the rest of the list.
I'm gonna put on my own fuzzy little size conjunction question marks, okay,
Can I posit that you're being very specific here with the phrase. Each permanently affordable unit converted from a hotel or motel room? These places have lobbies or lounges that are being converted into units.
Like,
Is this like a community kitchen, and so you don't have necessarily like a individual kitchen, but you might have like a communal space that you're turning?
No, I'm talking about the rest of the building.
you know, like,
The building could be converted, it
Yes.
could be a conference room
Yes,
at a hotel, and you say, oh, that's gonna become 8 units.
this is very specific, yeah, so I mean, I think you could just say each permanently affordable unit under this subdivision,
um,
something like that.
yep, that would work.
I don't.
Just- The hotel is more than just individual rooms, and so if you're gonna convert into a unit, there may be other places, it just.
Decided to.
Yeah,
I
you
do
could
bring
say
a
all-
conference room.
And it's very specific, but listen, but hey, but picturing the litigation and all the other sections.
I'm pro clarity.
Yeah.
Whatever that.
But it's very small.
That's why I wanna leave between clarity and the opposite. So it tends to not, it tends sometimes be different stuff. A frat house is shared residence. Each room doesn't have a kitchen, each person living there does not have its own kitchen.
They would not qualify for this.
They're not turning, yeah.
No, but I mean, it's that kind of arrangement of shared living,
Right, so I mean,
turn a hotel into a shared living.
so yes, there's a few different things that are happening, it's language, that there's even policy choice that you are making to require a kitchen. For each unit.
True.
In part because, we're saying they're independent living. Yeah, we're gonna, let's say, so. We've made some requests, you've made a further suggestion, let's look at it in our next draft.
Yep.
And with that,
Well, and finally, so you've been
Oh, yeah.
talking about a name, but no one actually gave me a name, so I inserted a name.
housing.
Where is it? Where's the?
The very last line.
Oh.
Is highlighted. So proposed name for this bill,
I mean,
enact relating to land use planning, development and housing.
It's not super marketable, but it is.
Disappointing to me. But I will, I will refrain, this looks.
Love yeah.
Loved it. Loved it.
So for now, let's leave that, and if people have brainstorms over the weekend, we'll find something more.
Not make her change it.
Lower where it's come to. Okay, thank you, council. Anything other questions on it, other than what's a kitchen? For now, I think we're not gonna be able to answer that. The Supreme Court has addressed this. You'll know it when you see it. Okay, the other things that I had in our thoughts, one of them was the Natural Resource Defense Council request. To have. Conservation districts.
Okay.
I mentioned.
Whoa.
Yeah. Actually, let me pass these out because Senator White has
Yeah.
requested. Mark here is, this is the list plus the handout you marked up.
Yes, and I only have, oh, okay,
Now you and I can share
I'm
one.
gonna do this first page. This is you.
Name six copies.
Oh, you have,
Happens when I give it
it's
to
attached,
you.
should be back page.
Can I have that?
Oh, of course. I know what it.
That's fine.
So, Mr. Chair, I'll just for brevity's sake,
Yeah.
the one piece that I think we feel collectively we should change, and obviously I haven't spoken with the Vermont Association of Conservation Districts. So this is going off of what seems to be similar in other sections, is the only additional place we would add. The conservation districts would be in section 27 in tier 3. Under B. So that seems to be the one that we would be most congruent.
Sorry,
So we wouldn't do the other ones, we just,
which one?
it would just be section 27. It's very faintly highlighted. Which is the third in the
Yeah.
part now. That's the one that I'm putting forward, if the conservation districts come in and wanna make a really stellar case for any of the others, I'm
Yeah.
open to it, but that's the one that seems with consultation from others to be the most reasonable.
I'm with you. Okay, anyone else have thought about?
And that would be adding them to the stakeholder work.
Oh, there's visuals.
Cool. So for now, let's do that. If people have further thoughts, including anyone who could be watching, they please reach out to your nearest committee member. Thank you, Senator White.
Yep.
There was also, Senator McCormick had a suggestion about, yeah, I'm not here to argue for his piece, but here's two copies. I think. Mr. Groveman, you helped Senator McCormick with this language. So can you maybe, and you're a lawyer, so maybe you could pitch in a little bit on what. What this is doing and why you think it might be a good idea.
Sure, so the Director John Groveman, Policy and Law Program Director for VNRC. So this issue came up as a result of a 2023 environmental court decision, ironically, about accessory on-farm businesses. So I won't go there under the existing law, but up until this decision, so the environmental court, like other appellate courts, would accept parties as friend of the court parties or amicus parties, which is just, you know, the Latin phrases for the friend of the court, a friend. Amicus briefs or what are filed, and they're usually filed by organizations. It could be, you know, it happens a lot at the Vermont Supreme Court. It happens at other appellate courts, and it's basically organizations. It could be like a VNRC. Like if an issue comes up in an appeal that could set precedent, that would go, you know, beyond just the you know, the parties are really arguing about the dispute, but often precedent can get set that has wider reaching consequences. And the parties, it could be an environmental group, but it could be a business group, so it's no limit to, it's not usually, it's not an individual, it's an organization. You have to show that, you know, you have a mission that is affected by a potential decision, and then you have a perspective to contribute to the court, to basically help the court kind of think more broadly about the implications of a decision. And until 2023, there were a couple of instances where parties would be amicus parties in environmental court, because as you've been talking about appeals with Act 250 specifically, understanding they can set precedent. There, you know, there were times where organizations would say, hey, we just want to file a brief, let the court, you know what the ramifications should be. But in 2023, in this particular case, there was an attempt by, it was actually rural Vermont, to file an amicus brief, and they were denied, and the court, and I can send you the decision, I have it on my computer, it's very short, but the court basically said, hey, you know, we hear appeals de novo. So they're, you know, they are an appellate court, but because they're basically it's not on the record appeal, and they're a little different than the other appellate courts like the Superior Court or the Vermont Supreme Court, and the legislature hasn't said that we can accept amicus brief filings. We don't, we're our interpretation of the authority to allow to accept the brief.
Yeah.
And so rural Vermont came to CLF and VNRC and some other groups and said, because VNRC had been an amicus party in the past in an environmental court, I think CLF was as well. And they said, hey, would you support us? It seems like the court is saying we don't have the authority to do it, so would you help us go to the legislature and ask them to clarify that they can accept these briefs?
Yeah.
It'll help everybody, like I said, it could be the Chamber of Commerce or VRC. You know, it's not like on one side or the other in terms of what your, mission is or your organizational perspective, but just letting the court hear from those parties. And so that's where it came from. And this language was,
Can I ask a quick question?
Yeah, sure.
It seems, maybe it's, sort of naive of me to think so, but, it's hard for me to imagine a downside of allowing someone to speak to the court about a case and provide information. The court is still gonna apply their discretion.
like, absolutely, it's just hopefully giving that perspective, like the Chamber of Commerce could come in and say, hey, if you interpret, we interpret the law this way, if you interpret it another way, here's some ramifications of that from our perspective. And, an environmental group could do the same thing from, their perspective. It just gives that report,
Okay, so it's
that broader perspective.
without bias, it's just you can bring. forward an opinion. Senator White.
Thank you. So just because I'm not familiar with how these kinds of relationships work. So it doesn't mean that a group like this would have like automatic party status.
Right,
And it would be there would have to be somebody who had already had an established like particularized interest and you're like sort of joining. Maybe not even joining that, but just advising.
yeah, exactly, that's a really good point, so,
Okay.
so it happens in the environmental, but it doesn't create any appeal, so the appeal is already happening.
Yeah,
So it's like, there's a dispute, someone applies for a permit.
Yeah.
And then there's a dispute between that party and whoever is like concerned about the permit. And then these legal issues come up, and it just allows these organizations to weigh in on that legal issue. Creates no appeal rights to like the Supreme Court. If the appeal went to the Supreme Court, the parties would all over again could say, hey, Supreme Court, can we file an amicus brief again with you? But no, it doesn't, it doesn't create party status or any of those appeal rights, yeah.
Okay.
So, counsel, do you have any thoughts on this?
If I just made it, so the language came from, we did, because we tried, it was worked up in the House, we did meet with Councilor Grady.
Yeah.
And Representative Lalonde, Chair of the House Judiciary. And talked, because we thought about trying to do this when the Act 50 bill was in the House, but they just didn't have time to get to it, but that's where that language came from.
We've got nothing but to that. So, Mr. Kowski. Any thought on anything you'd want to make yourself aware of, maybe around this issue?
I'm not prepared to speak on this.
You what?
I'm not prepared to speak about this.
Okay,
I did not know that. I did not know the connection that you just described to what Senator McCormick,
me neither.
so.
Worrying on the every day. There is a phrase here, to the extent the judge deems advisable in the sound discretion of the judge. Which, why is it qualified in that way? Why didn't it just sentence basically needs a tweet, but end it? Shall be allowed to participate by amicus curiae, period, like, I didn't really have that other stuff.
It's always, and I don't know where that language came, that exactly from, I'd have to talk to Councilor Grady, but there's always discretion. I mean, you have to convince the court that the amicus brief will, that there is an issue, a broader issue in the case that could have an effect, that it could, and that the organization's mission is relevant to that, and that organization could provide some beneficial assistance. So it's always discretionary. Usually courts like these briefs because it helps them, right? They're not doing the work, they just get, more information basically. But there is always discretion, whether it's at the US Supreme Court, where this happens all the time, and the Vermont Supreme Court, where this happens a fair amount. I'd have to go back and look at the state, like if that, I'm assuming that mimics sort of the standard for amicus briefs at the Supreme Court and in the rules of appellate procedure. But I have to go back and look at that, I was just kind of relying on the draft.
If you could look at it,
Yeah,
great.
yeah.
I can imagine stopping and then at the word advisable.
Yeah, I think you want to leave some discretion, but I'll go back and look, it'll take a second, at the rules of appellate procedure. And make sure that the standards line up,
Okay.
but there will be some discretion.
It seems like you would cover it by just saying to the extent the judge keeps advice. Or in the judge's discretion, whatever, but there may be a reason for, it feels like balance is.
Yeah, it's a good question.
Okay, if you can chase that down, that'd be great, Senator McCormick, thank you for your suggestion.
I apologize for not being in the room.
Yeah.
It was not.
Yes.
And as far as the, it sounds as though the case has already been made.
The case has already been made.
So I'll just shut up.
So they say, put while you're waiting for it.
Yeah, don't say anything.
So, are we fine in the committee with adding the Wayne? Ready? Perfect, there we go. Okay, so let's put it in and, Mr. Groveman, if you could chase down the origin of there's
Yeah.
other ways of expressing it. that-
Absolutely, thank you.
The Department of Redundancy Department could take a look at it, sorry. We have, I think just, and I think it's, we don't have time to go through it, but to have everyone have a copy for, because obviously we're gonna see at least an amendment based on today's work. And yesterday in committee, I had asked, we had discussed appeals. And I asked Mr. Groveman if he could be kind enough to get the ball rolling on how we might talk about appeals and study or report. And so we don't have, we're gonna be on call for 4 to 3 minutes, and this is a complicated topic. But I wanted to share your work product. Thank you, Mr. Groveman, for jumping.
Yeah, no, thank you.
in. And then ask committee members to read it and think about it this weekend. For thinking about appeals, what are all the questions we might want to ask if we're gonna study? But put ourselves in the best possible place to think about appeals going forward. Knowing that our current default in the bill is, the environmental division is superior for the near term and the natural resources board for the longer term. And knowing that there's some back and forth about the advisability of one of these and just to put this question on the table, something I've been mulling over for myself in the last 3 days is if we are going to study and ask, and it would be the same group of folks, I think, so we get this list. One thought I had was that the group that was the necessary update support group delivered what became the 308 language that was the seed that became part of 311, became 687. So it seemed like it was a productive work group to use that group to look at appeals and how we might improve it. And I'll share the question that's occurred to me in the last several days, which is if we're going to study the best possible posture and place and way of managing appeals, quite frankly, I'm not sure that including the pros and cons of the environmental division versus over at the board, does it make sense to make that decision prior to getting the report, the workshop of the study group? And, I would say as much as I want to see a fully fledged natural resources for the hearing appeals, I have to be fair or whatever, rigorous with myself and say, if that's a good idea, the work product of the study group should make that clear and why, and we might not make a decision without having done the study first. And if it's a winning proposition, it should win not just today, but it should win 12 months from now, or whatever it is we have that before it. And then practically speaking, I don't know that makes a difference to, if we do go that way, I don't know that we've lost any time in making progress in moving to the board. Meanwhile, we're beefing up the capacity of the environmental commission. In order to, we hope, facilitate the hearing of appeals while they still go ED. So I'm just being transparent about questions that's occurred to me, and just because I was all in on one proposition last week doesn't mean I'm not gonna ask myself the same questions. I mean, and to ask other people to come in here with propositions for us, so. With that, any other comments before we wrap for the week?
A question about process.
Sure.
So, is the intention anyway to try to draft or vote out on Tuesday?
Yes.
Okay.
Well, I'm doing that,
No, well, you didn't really do that much.
right. I'm wondering if it will be more practical to look at what we've talked through today in the same format again. So it's instances of amendment to avoid the whole giant draft syndrome. And that'll make it easy for us. If there are other things that people want to resolve, we didn't get through everything on our local punch list. And there may be things people said, okay, we got as far as we could today. If there is anything, I'd ask everyone in the committee to look at that punch list over the weekend and basically ASAP work on gathering information, knowing who witnesses might be, drafting some language, working with council on draft language, so that when we sit down on Tuesday, we'll pretty much be, I think, closing the book on what our amendment looks like. Okay, the other thing I wanted to say, it has been a very challenging week, and I just want to thank everyone in the room, committee, council, for everyone just hanging in there and keeping on working, even though it's not been it's been a difficult process. There's a lot of pieces moving. I appreciate that we keep coming back to trying to put something clearly in front of all of us on the table and keeping it public so that people can follow the committee and outside.
We don't need to come in on.
We don't, unless you're gonna make a
Yeah.
motion.
Okay. Just confirming.
Confirmed.
Thank you. And thank you for your really diplomatic negotiation so far. I think that we've gotten a lot farther in a conversation that for a long time has stalled, both in our state and in this. Thank you.
Well, we won't count any chickens till they hatch,
Sure.
but we have. With the metaphor right there.
It's okay.
Thank you, we are adjourned.
Still work. The other work.
The other. Okey dokey.
Oh.
Hey, and you know, for chickens, she's doing your street.
Yeah.
Yeah.
Very bad. Yeah.
Strong.
And I don't know if you count it because that.
Right.
You sure? What, like, why do you? Now they're.
Are we still on?
Yes.
I'm getting treated.
Well, you guys have to find it's the